a comma here and another sub-paragraph is really just playing games and not applying the proper test. So that's the one thing. So the TRC Association and the NPA associations are, in our respectful submission, themselves grounds which, and we accept that this is not for this commission. The president is the one who did the appointment. But that appointment, for what it's worth, and in the correct forum, is itself to be criticized. Now, then we come to the other ground. I want to come last to the actual bias ground. Justice Khomo says to my learned friend, Ms. Muvangwa, that what we expect is that Advocate Semenya must prove a negative. But where does that come from? Nobody's expecting Advocate Semenya to prove any negative. There are positive, pointed assertions that are made about being given advice, or what that advice is about, or how it should be conveyed to Advocate Soni, and so on. Where's the negative? Those are positive assertions. If someone wants to disprove that, it's simple to say, it has never happened. I was never given such advice. I don't know what you're talking about. It's not as impossible as it is portrayed to be. That's all you do. If I receive an affidavit today that says, today I was in Cape Town doing this and the other, I'll say, no, I was at the commission, I was arguing a matter, and so on and so on. I'm not proving any negative. If somebody makes any assertion positive that I was doing something right at this hour, it's within my gift to oppose that. So let's not, again, create a case that is not there, because the case is here in front of us, and it's very simple. Then there's the issue about the so-called language issue. Firstly, I don't know what this language, we're not told what the language that Mr. Soni is complaining about is. But assuming it is contained in the affidavit, I honestly don't know what it is, except for what I explained this morning to Justice Khomo about the fact that somebody who has been subjected to what I've described as detention without trial is entitled to feel strongly. And if they're entitled to feel strongly, well, then they're entitled to express those feelings strongly. I don't know what it's like. I was only detained without trial under apartheid. But if someone had asked me to describe that experience, I don't think I would do it in hush-hush tones. So that's really the only answer. And it's very rich coming from Mr. Soni to complain about language. When he has, in their papers, they've accused us of the things that I cited earlier, Justice Khomo. And not only that, sitting there, in the same breath, he was casting aspersions on President Mbeki as being basically devious and disingenuous, because the only reason that he wanted to do this application was because he didn't want to because there's the Zuma application and so on. All the things, the ill will that he was ascribing to, not only to President Zuma, but to President Mbeki. And by the way, he says the reason why he takes exception, or why there must be different treatment, is because Mr. Semenya is making comments about a litigant, and Mr. Zuma is making comment about an esteemed judge who held high office. Well, both President Zuma and President Mbeki held high office as well. So if it's going to be a contest as to which office is higher than which, well, then so be it. So you can't be entitled to castigate people who held high office if your philosophy is that people who hold high offices should not be castigated. What's sauce for the goose is sauce for the gander. Now, the issue of another mistake that, to put it politely, that the evidence leaders are making is the issue of the context. You know, it's been said that in law, context is everything. So we're told, for example, about that Advocate Semenya, in relation to the issue about the affidavit, is entitled to do the affidavit because judges typically don't do affidavits, particularly in matters that concern them, which is true. But that's not the point we're making. The point, firstly, the point is that counsel also does not make affidavits for the same reason. Counsel ordinarily doesn't make affidavits about cases that they are involved in. But in this particular case, all we are saying is that you have a situation, and this cannot be controverted. You have a situation where somebody says, I'm acting on behalf of X. Everyone is entitled to act on behalf of anybody. But once that authority is challenged, you can't keep mum. I mean, I don't know. You can't then say, if someone says, I'm authorized by my learned friend, and someone challenges it, and then I do nothing, then that challenge is requited or unanswered, and therefore it remains like that. There was nothing stopping the evidence leaders from putting an affidavit or saying no, this and that and the other as an explanation. So every allegation, and Mr. Soni really is testing our intelligence, because he says that he concedes. He says, yes, we accept that Advocate Semenya could not make an affidavit about the matters raised in the application, but he can make an affidavit about matters that affect him personally. In other words, the allegations of giving advice and all that. But that submission can only be made by somebody who has never read the affidavit of Advocate Semenya, because that affidavit says zero about what he says it is entitled to do. It says exactly the one that he has considered, because it says no about the judge and her history and so on, things that are clearly in the personal knowledge only of the judge and not Advocate Semenya. The part that Advocate Soni says Advocate Semenya is entitled to attest about, he doesn't. Because he's right. He could have said, no, I didn't receive that advice. Oh, no, I was not in South Africa at the time or whatever. But he says nothing about that. So that is a concession by the evidence leaders that the affidavit in front of us, the one here, is of the prohibited kind. And the one that they say is of the allowable kind is not this one. So what more do we really need? And that's why I was saying, when you do a confession and avoidance, if you don't have the avoidance, you are only left with the confession. And that's what we have in this case. There's a confession that says, effectively, the defense being given to you, this panel, is, yes, the advice was given. Yes, it was, because those are not disputed. Yes, it was to say, to tip or to coach Advocate Semenya to give advice to Advocate Soni as to how to argue the case. Those are the allegations. Coaching, collusion, and but no, the avoidance, attempted avoidance is no, but they talk all the time. Really? How does that address the pointed accusation of giving advice whose content is given and whose impropriety is patent? It doesn't. And therefore, those allegations must be taken as given. Then Mr. Soni says that correctly, says that I think it was Mr. Vani. It's got that a predetermined outcome. I mean, the most typical manifestation of the Nemo Iudex rule is arguing a case in front of somebody who has a predetermined outcome in their head. That's the most, because what's the point then? You might as well just keep quiet and say nothing. Because whatever you say, you can quote 1,000 books and what have you. If the person has a predetermined outcome, it's not going to succeed. That is what is called bias. And what is better bias or demonstration of a predetermined outcome than somebody saying, when there are two adversaries, you must do this, you must do that, you must do that. For what reason? So that you can win, so that my predetermined outcome must prevail. So, sometimes lawyers complicate things. The simple example is this. You have a soccer game, and the referee goes to the change room of the other side and say, no, you must change, you must play this one. Be careful of that striker, and so on. Who does that? It's which team, once it gets to know that knowledge, that the referee went to the change room of the other side and advised them on how to win the game, would you continue playing the second half? I wouldn't. Because what's the point? You might as well give them 10-0. We're not going to waste our time playing this game. And that's all we're saying, really, to simplify it. We are saying we cannot be expected to play a game that is fixed. And it is not true that, or rather, it is mistaken for my learned friend, Mr. Soni, to make the following submission, that simply because the alleged bias is in favor of Mr. Semenya, then what are we complaining about? I mean, that kind of submission boggles the mind. How can parties that are going to be subjected to a process in which Mr. Semenya is the evidence leader, he's going to be questioning those parties, be told that, well, so what if Mr. Semenya is favored? And yet the same parties say that in their heads of argument, Mr. Semenya must be regarded as a prosecutor. They say the best way to understand his role is you must regard him as a prosecutor in a case. Now, if we follow their own analogy, which litigant would say, no, only the prosecutor is biased, and the judge is in favor of that prosecutor, but that bias is not against me? I mean, what is that? I can't even work it out in my own head, what that submission is. In short, the mere fact that there is bias to do with one of the players, whether they're a prosecutor or an evidence leader or whatever, affects both presidents directly because they are the implicated parties. And just on the jeopardy, I think in the heads of Mr. Mbeki, this point is made even better, which is that one of the mandates of this commission is to recommend criminal prosecutions. So the prejudice to those people facing possible criminal prosecution is clear and manifest. I don't think I need to belabor that point. And at paragraph 43 of our heads of argument, we make the point. And we quote the famous case of Rare Pergamon Press Limited. And this covers both the point that I just made and also the so-called inquisitorial process point, which is that simply because the commission makes only recommendations, it doesn't matter. It can be biased, basically. That's not true. This is what Lord Denning said in Pergamon Press. talking about something even less than this commission. It is true, of course, that inspectors are not a court of law. We concede that. This is not a court of law. Well, actually, that's a point we made earlier. Their proceedings are not judicial proceedings, it says. They are not even quasi-judicial, for they decide nothing. The point made by my learned friends in their heads. They determine nothing. They only investigate and report, like this commission. Investigate, make findings, and report. But here's the sting. But this should not lead us to minimize the significance of their task. They have to make a report which has wide repercussions. They may, if they think fit, make findings of fact which are damaging to those whom they name. They may accuse some, they may condemn others. They may ruin reputations or careers. And Lord Denning were therefore to say, therefore, they must be held to the standard of fairness. And the standard of fairness is manifested in the two rules of natural justice. The most well-known is the aude alteram partem, but its other cousin is the nemo iudex. And if those standards have been breached or perceived to be breached, reasonably so, then that should be the end of the matter, honestly. And if, on top of that, the allegations that have been made are not disputed, then the case, whether it's the actual bias or the other case, must be then decided on the admitted facts. The admitted facts are set out clearly in the affidavits. The admitted facts in relation to the actual bias are set out in paragraph 38, 39, and 40, and they have not been denied. And my learned friends, both Mr. Vani and Mr. Soni, thankfully agree with me, or at least express agreement on the issue of the sufficiency or cogency of evidence. And the only question that stands before you, honorable commissioners, is whether on the evidence that is presented, not the evidence that is not presented, on the evidence that is presented, and you'll find that summarized, in our heads of argument at paragraph 56. So on this argument, is there a case or not a case for actual bias, alternatively reasonably apprehended bias? And we say, under this topic, two pointed accusations have been leveled against the chairperson, namely collusion in the form of 1, collusion by giving legal advice, 2, and or sharing helpful research with one party to the dispute before her. 2, coaching in the form of pointing out potential pitfalls to the implicated party and even going as far as to propose what instructions are to be given to the legal representative of that party, Advocate Vasoni SC. 3, doing all of the above without the knowledge of the applicants, privately and or secretly. In short, the conduct was undisclosed. I dealt with this earlier. 4, doing so with the intention to assist Advocate Sminya to succeed in the recusal application, which was yet to be argued before the very same chairperson. And 5, to indicate knowledge of unlawfulness, conveying the impugned message from her private email address and not the one officially assigned by the commission. And you can add the 6, what is referred to in the replying affidavit, which has not been disputed, that there were not only those emails, but there were also WhatsApps. So the point is that, is this...
What about the WhatsApps?
If you go to the replying affidavit, sorry, Justice.
That is your point 56.6.
That was the heads. But now I'm going to the affidavit. The reply. Okay, I'll find it now, Justice Home. Let me just paraphrase. What we say in the reply is that I have to read it as it is put here.
Yes, paraphrase if you wish.
Yes. Please find the reference to the WhatsApps. Sorry. Yes. I'll paraphrase it so long. Malena Junior will find the passage. What is alleged in the your only job is to say, if these facts are true, if such advice was given from a private email and so on and so on and so on, is that not evidence of actual bias? One. If it is not, would a reasonable litigant in the position of former President Zuma not reasonably hold a perception of bias or apprehension of bias? Those are the only two questions. And the answer to those questions is yes and yes. In any world, anywhere, whatever anybody wants to say, the answer to those questions will always be yes. There's nobody who's allowed to be a decision maker and yet participate. You can't be a referee and a player, as the saying goes. If you must choose which one you want to be.
Mr. Mpofu?
Yes,
I must draw your attention to
the time. Yes. Thank you, Justice Khampepe. Yes, I'll wrap up. Let me just check my notes.
You are actually 15 minutes over.
Yes. Okay. Well, all right. I was not counting. I'll take your word for that, Justice Khampepe. Yes. Okay. The point I made. I don't have to reply to this because there was no countervailing argument. But the point about the only problem is that Mr. Soni, I think, just ignored what I was saying about the fact that this is not about the recusal of a judge, this case, the one we're talking about now. It is about the recusal of the chairperson of a tribunal who happens to be a judge. So the test is not the test of somebody sitting in judicial proceedings. That must be made clear. And therefore the presumptions don't apply mechanically as Mr. Soni would like us to believe. Then Mr. Soni says, or one of them says that Mr. Zuma has not put up the evidence. I think I've answered that. He has put up the evidence. Is the evidence complete? We are the first ones to say it's not complete because of the withholding of some of the evidence. But that's not the question. Is the evidence sufficient for the finding that we want this tribunal to hold? The answer is yes. It is sufficient. And then, sorry. Yes. The last point, hopefully.
Not hopefully, Mr. Mpofu.
Okay, last
but
point.
It should be the last point.
Yes. No, it is Justice.
Hope springs eternal.
Yes, well, we live in hope. Oh, yes. Okay, I'll hold this. This is the real last point. The point I wanted to make, no, this point is not mine, it's just Ms. Sokela wanted to just make one point. In fact, I should have allowed her to do that before I started. So with your permission, when I finished, she just wanted to I completely forgot. She assured me that it's really 1 minute, not a minute. Now, the last point I wanted to make is this, Justices, Homer and Commissioner Gabriel. And it has to do with the issue of so-called unreasonable delay. It is now common cause between us as parties, from what I heard, that even if, let me put it that way, even if the unreasonable delay point was good in relation to the occupational history, which obviously was known before, and in relation to both the TRC or in relation to the judgments of the Constitutional Court, obviously. That point cannot be good in relation to the main point that is raised by President Zuma, which is the giving of the legal advice. So even if one, that was correct, and B, even if it was a complete bar, it obviously has no effect. So really, there's no escaping dealing with the actual bias point and the point that is made. Now, I'm going to sit down, Justices, but please allow me just to say this in relation to the Kalata group. That yes, there's nobody more than President Zuma, and I presume the other applicants as well, who would like this matter to be resolved. These are people who are freedom fighters themselves. And these are people who want the outcome to be as clear and pure as it should be. Very few people, anybody who has any sense of what has happened in this country would say otherwise. I might be the only person in this room who attended the funeral of Matthew Koniwe, Kalata, Mhlauli, and Mkonto. And anybody who knows the level...
You were still very young.
Pardon?
You were still very young.
I was, but I was at the university. It was in July 1985. And the state of emergency was declared on that day, and we were arrested without trial by P.W. Botha. But that's another story. But anyone who even remotely had any sense of the amount of atrocity involved in those evil deeds cannot, even for any selfish reasons, want to stop a process that goes to dig into that process. The AfriForum was here I suppose they represent those people. Maybe they would want to delay it, but certainly not President Zuma, because these were his comrades. And the issue about going to the bottom of this issue must be done, but it must be done in a commission that is with integrity, that is beyond reproach, and that is neutral and able to give South Africa the answers that it needs in relation to those atrocities. Thank you very much. I'm indebted for the extra time.
Thank you, Mr. Mpofu. Ma'am, I didn't get your name.
Sokela.
Thank you, Chair. It's Kumzile Sokela.
Sokela, yes, Ms. Sokela.
Chair, I will, and Commissioners, I'll be very brief. Mine is just to seek to clarify an issue that my learned colleague, Advocate Soni, had raised in his submissions, and my colleague, because of time, didn't deal with it. And it relates to... Oh, it is on. It relates to the issue of the consent ruling. The consent ruling that was done on the 27th of November, and it was in relation to the Kalata group's request for the leading of evidence. I hope I understood correctly what Advocate Soni said in relation to that. My summary of it is this. It is that the complaint about how the evidence would be handled, the Kalata evidence, or the leading of the evidence, had been settled in the ruling. So the matter is done and there's no controversy about that, and we are in effect seeking to rehash a settled issue. I just wanted to correct what it is that the ruling consented for. And I will invite the commissioners to go to the Kalata group's answering affidavit, to our founding affidavit. It is at page 20, paragraph 86. And there they quote the ruling in full. In paragraph 2 of that ruling, it is said that after having heard the parties, the Commission makes the following ruling. 2, there is currently a request by the Kalata Group to lead the following witnesses, and then it lists those witnesses. Paragraph 3 of that ruling says that the reasons for the Kalata Group's request to lead the witnesses are set out in their submissions. And then paragraph 4 says that the substantive objections of other parties to the request are set out in their submissions. And then it goes on to deal with how future asks will be dealt with. The Kalata Group explains it the same way in their answering papers. They say in paragraph 87, after that ruling, the Commission adjourned to consider 1, the Kalata Group's request as set out in their submissions, and then 2, to consider the substantive objections of the parties. Now, we have dealt with this to seek to clarify in our answering affidavit to Mr. Semenya's answering affidavit, in our reply, pardon me. And it is at page 37, paragraph 121, where we, in essence, explain or confirm what it is that the Kalata Group's understanding is about what the consent order does. And we say that the agreed upon order was not to settle the issues, but to allow the chairperson to consider the request made to her for the first time and the objections raised by the parties. So I hope it is now clear that to the extent that there is a consent ruling, it wasn't to seek to settle the dispute about the leading of witnesses. That was an issue still for the Commission to determine. I hope that that's now clear.
Yes. Thank you, Mr. Kelly.
Thank you, Chair. Thank you so much for the time.
Well, I thank the parties for their argument in this matter. The ruling is reserved and we are adjourned for the day. Mr. Siminya.
Good morning to the Chair and co-commissioners and to my colleagues, friends, and everybody else. Today is a set down for the hearing of an application for the recusal of the Chair. I suspect we will all put our names on record. I represent the evidence leaders together with my team.
Yes.
Good morning, Chairperson, Commissioners, and colleagues. My name is Mpofu. I represent former President Jacob Zuma, together with my learned friends, Mr. Buthelezi and Ms. Siwunu.
Good morning. We represent the Kalata Group. I'm here with my learned friend, Santo Pele, instructed by the voice.
Thank you, Mr. Van.
Good morning. My name is Nyopo Muvangwa. I represent the former President Thabo Mbeki. I'm instructed by Bokwana Burns. I appear together with my learned friends, Ms. Sokela and Dr. K. Moyo.
Can I request that you give me the spelling of your surname?
Of my one?
Yes.
It's M-U-V-A-N-G-U-A.
Muvangwa. Am I correct?
Yeah, that's
Muvangwa.
correct. That's correct.
Thank you.
I must apologize. I omitted to mention that I also appear on behalf of the former cabinet ministers who are documented
Yes.
in the papers.
Thank you, Ms. Muvangwa.
Morning, Chairperson, Commissioners. I will be presenting evidence on behalf of the evidence leaders today, Chairperson.
And your name?
Oh, sorry, it's Vas Soni.
Thank you. I intend to allocate 30 minutes to each counsel for the main argument and 15 minutes for the reply.
Thank you.
Mr. Mpofu?
Yes, thank you, Chairperson.
The ball is in your court, sir.
Yes. Thank you very much, Chairperson. Yes, what I will then do is, all right, I'm going to sequence the argument slightly differently to what I had planned, given the amount of time allocated. Chairperson and Commissioners, this is a recusal application brought by the former President. It has always been said that a party that brings a recusal application has a very unenviable task, and that according to our courts, the motives of such a party should not be lightly questioned. This application is particularly in that realm because, firstly, from a public point of view, it involves very serious matters involving the TRC and part of our history, which is really forms part of the DNA of this country. But also it involves very senior former presidents, very senior judicial officers, and very senior practitioners. For me personally, it involves my real learned friend, Mr. Smenya, and other people that I consider to be brothers and sisters. But enough of the sentimental stuff. We have to get on with the job. The application is based on 3 grounds on its merits. And those are, as we've spelled out in our heads, we've rolled up the grounds that, if you count them mechanically, you'll find 5 separate grounds, but they can be rolled into 3. And that even includes the overlapping grounds in the Mbeki application. But before I deal with those, with the permission of the Commission, I would like to deal with the preliminary points that have been raised reciprocally by both sides. The one preliminary point raised by us and in the Mbeki application as well is the competency, authority, and status, if you like, of the answering affidavit, to the extent that it was deposed to by Advocate Semenya, who is the chief evidence leader. The second such preliminary point is raised by the other side, and for shorthand, let's call it undue stroke unreasonable delay. And it is argued that the so-called undue unreasonable delay is a complete bar and necessitates the dismissal of the application up front. Needless to say, our position is that the preliminary point raised by us should be upheld, and the one raised by the evidence leaders dismissed. For the following reasons. In respect of our preliminary point, it is trite that a party that deposes to an affidavit on behalf of another should be properly authorized to do so, number one. The other very trite, or even more trite, rule is that when such authority is challenged, then the party that, whose authority is challenged attracts a duty to then prove that authority. In this case, we raised that objection in the answering affidavit, and until today there's been no response. No affidavit, no nothing, basically, to gainsay the challenge to authority. That alone should be fatal to on this issue. But putting aside the non-response, the issue is based on the following grounds. Firstly, you would have noticed that in the application, the cited respondent is the chairperson of this commission. But the answering affidavit, so-called, purports to have been done on behalf of the commission. Even if it was done on the commission, our view is that our submission is that the commission is not per se the respondent. But let's assume for argument's sake that it was. Then there would still have to have been an act of granting authority to the deponent, which is sadly lacking in this matter. It is again tried that where authority is challenged, if it's a juristic person, then the party produces a resolution or whatever it is. Or if it's a human person, then they produce a confirmatory affidavit from such person. None of that has been done. The
so
second,
we would have liked to see something like a resolution, Sisi Khampepe hereby resolve to authorize Ismail Semenya SC to depose to the affidavit on behalf of myself and or the commission. That's
No.
what you have
No,
wanted to see. What did you want to see?
no. The chairperson is not a juristic person. I said, if it's a juristic person, that means an inhuman agent, then you produce a resolution because a company doesn't have life. But if it's a human person, then you produce a confirmatory affidavit. That's what happens every day in our courts. But in any event, the challenge must be met. That's the whole point. Here, we don't have to go into whether it's a resolution or whatever. The challenge has simply not been met with any response. The second ground upon which we base this is that my learned friend, Mr. Semenya, says in the relevant paragraph that he has an interest in this matter. And then in the heads, he says he's a witness, effectively. And in the same breath, he says he gave legal advice. You can't do that. If you have an interest in the matter and you are a witness, then my learned friend would know better than me. Then you are precluded from also rendering legal advice in that same matter, let alone to act on behalf of the respondent. The last ground is that Mr. Semenya, to the extent that he is indeed a witness, is for that reason, and the one that I've just mentioned, a witness in the matter, and therefore conflicted. On that basis, then, what that means in reality is that the application is unopposed. Because if the answering affidavit is incompetent for whatever reason, then it must be read as pro non scriptura. But assuming that the commission will find that despite all those defects, the affidavit is competent, then I move to the preliminary ground that is raised by them. And it goes like this. The commission was appointed in May, I think, and then the application was brought in December, therefore there was a 6 months delay, something along those lines. Well, firstly, the factual basis of that objection is false, in the sense that it is said that the former presidents ought to have known that the commission was appointed in May or whenever it was. There's no legal basis that is pleaded as to why they attract that duty, or why they attract it more than any other South African, because there was no notification given to them. There's no constructive knowledge that can be attributed to them. Obviously, it should be obvious to everyone that the first time, at least former President Zuma, got wind of the fact that this commission implicates him or needs evidence from him or whatever, was when the Rule 33 notice was granted. So that's really the starting point. The starting point can never be May. It must be the time of the Rule 33 notices. Speaking specifically for former President Zuma, he wrote, through his attorneys, Mr. Kwinana, he wrote a letter to this commission, to the secretary of this commission, stating that he was overseas. I'm paraphrasing. It's Annexure B to the founding affidavit. He was overseas. He had not had time to consult with anyone. He would attend to the matter and get legal advice, words to that effect. So again, how can he, when he had not even seen the documents or engaged or consulted with anyone, how can he be faulted for not taking steps at that stage? Then, of course, the main ground raised by former President Zuma, namely the alleged misconduct and conflict of interest, on the part of the chairperson and or Mr. Semenya. That ground obviously arose only upon in the last couple of weeks before the commission was given. And to be fair to the evidence leaders, they don't raise the point that on that particular ground, it should have been brought earlier than when it was brought, which was, as I say, within a couple of weeks. So even if the so-called unreasonable delay ground was good, which it is not, it would obviously not be, it would not defeat the entire application, particularly the main ground raised by former President Zuma. But in terms of the law as well, and I'm not going to belabor this because we've dealt with it in the heads, there's no law that says that unreasonable delay is a complete bar in recusal applications. It may be a complete bar in terms of reviews, given the 180-day rule in Paja and so-called unreasonable period in terms of legality. But there's no authority that I know of or that can even exist that says undue or unreasonable delay is a bar. And that is known. I don't have to say that I'm preaching to the converted, because this commission dealt with this in November. When the Semenya SC recusal application was raised here, the objection was undue delay. And this commission dealt with the matter, and at the end of its ruling, it said, well, the delay was undue, we deprecate that. That was it. In other words, even when the undue delay was found to exist, it was never seen by this commission to be a bar. So it cannot start now to be a bar. So much for the undue delay. Now, coming to the merits of the recusal grounds, assuming again that the affidavit is regarded as authorized. This is what I propose to do. That's the adjustment I was referring to save time, because the time is quite short. The main ground raised by former President Zuma is the one that relates to the alleged misconduct by us in the form of giving advice to the evidence leader on how to succeed in the Semenya SC recusal application. The second ground is the ground which, again, for shorthand, I'll call the occupational history ground. And that's the ground that deals with the fact that the chairperson was previously employed by the Truth and Reconciliation Commission, its Amnesty Committee, and the NPA as the deputy NDPP. Now, then the third ground in the Zuma application is, of course, the utterances, attitude, hostility, vengefulness, hatefulness, all those that are pleaded in the founding affidavit associated with the detention without trial of former President Jacob Zuma. So this is how I propose to deal with the matters. And I want to be understood very clearly on this point. The third ground that I've mentioned, that's the Constitutional Court ground, is, if you like, is the alternative ground. If you go to the notice of motion, which you'll find, not our notice of application, which you'll find on page 2 of bundle A, you'll see that I think prayer 2 says is for the total recusal of the chairperson, and prayer 3 is for the partial recusal, if you like, only in respect of former President Zuma. So that ground is an alternative ground by any description, in the sense that it only talks to prayer 3. If it succeeds, put it this way, if only that ground succeeds, then obviously the chairperson would not recuse herself in total. She would recuse herself partially, quote unquote, in respect of him. So because there's no time, we can park that ground. We're not abandoning it, but we're parking it because I want to highlight what I call the main ground. The second ground, other than the one that I'm going to deal with, is the one of the occupational history. Now that ground for us is, and one can argue these things in any sequence, I'm just trying to give a logical sequence. The second ground that I want to deal with is the occupational history ground. I'm not going to dwell much on that ground for two reasons. One, it is the main ground as far as in the Mbeki application. So I'm anticipating that my learned friends from President Mbeki will speak extensively on it. Two, our submissions have been extensively put in our heads and in the founding affidavit, and all of them must be taken as read. But three, most importantly, as a matter of law, our ground, main ground, which I'm going to talk about now, is based on actual bias. And former President Mbeki's grounds are based on a reasonably apprehended bias. Now, as a matter of simple logic, if the ground on actual bias is upheld, then one doesn't have to bother about reasonably apprehended bias at all. I don't think I need to motivate that. So, as a result, for the reasons, three reasons that I've just mentioned, again, that second ground, as far as we're concerned, is persisted with, full blast. But for the purposes of oral argument, I will simply refer to it at the end, to the extent that I will still have time. Otherwise, we'll deal with it in reply. So everything we've said in the affidavits and the heads must be taken as read. So that then leaves me with the main ground raised by former President Zuma, which is the actual bias ground. That ground, as I say, is fatal to, if it's upheld, it's fatal to the entire case, then there would be no need to deal with the other two. Well, there might be a need to deal with them to the extent that the matter might go further than this. But for the purposes of the decision today, there'll be no need to deal with them. Why do I say that? One of the fallacies that appear from the papers of the evidence leaders is to conflate is an understatement, but to mix up the test. The test for bias, the test for reasonably apprehended bias must never be conflated with the test for actual bias. So, a simple example to demonstrate this is that we know that there's the so-called double reasonableness test, which comes from Sarfu, Sakau, and that line of cases. It should be obvious to anybody that that test only applies to reasonably apprehended bias, not to actual bias. Why? Because when you talk about double reasonableness, you are already talking about the reasonable person. In other words, you're talking about the objective test. But actual bias has got nothing to do with that. You can't say someone is actually biased because a reasonable person will think that they are biased. That's just terminological, not even an oxymoron, but it's senseless. So the court, or rather this forum, would then be spared if there is a finding of actual bias. It doesn't have to go into the double reasonableness test. Similarly, another test which they invoke is the presumption of impartiality. Again, the presumption of impartiality cannot apply in this situation. Because here, although the chairperson who is being asked to be recused is judicially trained and held very high and esteemed offices in the judiciary, she is not being asked to be recused as a judicial officer, per se. She's being asked to recuse herself as a chairperson of an administrative body. So it cannot be that if, let's say, this was the recusal of Archbishop Tutu in the TRC, because he was not judicially trained, a separate test would have to be applied. But simply because the chairperson here happens to be someone who's judicially trained, then the test is different. That's also legal confusion. So, and let me put it very simply. A judge, qua judge, is never appointed by the president in the way that a chairperson of an administrative tribunal is, number one. Number two, when a person is sitting as a chairperson of a tribunal, they are, as it is said in the heads of argument of the other side, they are, in a way, they are subservient to the person who appointed them. That's why it's said that they can only make recommendations. They can't act. The only person who can act is the president. Unlike a judge, when a judge issues an order, he or she doesn't depend on the whims of anybody to do so. So there's a vast difference between someone sitting as a judicial officer and somebody who happens to be a judge sitting as the head of an administrative body. With the greatest respect, a person sitting, chairing an administrative body appointed by the president is in no better position than an advisor to the president. In fact, that's what they do. They advise the president or make recommendations to him. They are in no better position to a director general who may make suggestions to the principal.
But the recommendation is based on finding. Now, where does the whim come in, or the influence? The chairperson would make a decision fact-based and not on the whim of the president who appointed.
Yes. No, Justice Khampepe, I think maybe either you didn't hear properly or I misspoke. If I did, I apologize. The whim is not at the level of the finding. You're quite right. The decision maker, any decision maker, whether it's Archbishop Tutu or whoever it is, makes a finding. That you can put aside. The whim comes like this, and this is trite as well. Once an administrative body makes recommendations to the president can literally take the thing and put it in the dustbin. Okay? That's where the whim is. When it's a court order, he can't do that. So that's the difference here. So that's, if I put it the way you're putting it, then I misspoke. Yeah. So the whim comes on the end of the implementation. And that is why, if you will remember that one of the defenses raised in this matter is exactly that this commission only makes recommendations, and it's correct. So that's where the whim is. Now, that, by the way, is another defense which has short legs, which doesn't carry any water, because it's related to the defense that says the commission is inquisitorial and not adversarial. That defense cannot go anywhere. It should die before even arrival. Because the Yes, of course, the Commission itself, in terms of its terms of reference, carries its work inquisitorially. But this is a sui generis application, the recusal application, as was the Semenya recusal application for that matter. And the recusal application is clearly adversarial. So the fact that the Commission itself might be inquisitorial is neither here nor there. And to the extent that it is adversarial, it is improper conduct for the chairperson to give advice to one of the adversaries. Plain and simple. If the matter is adversarial, as it obviously is, then the rule that applies is the one that was enunciated in the SCA in S versus Roberts, 1999 4 SA 915 SCA at paragraph 23, that you'll find in the preamble to our heads. And it says as follows, it's very simple. That justice publicly be seen to be done necessitates as an elementary requirement to avoid the appearance that justice is being administered in secret. That the presiding judicial officer should have no communication whatever with either party except in the presence of the other. Now, this is what we call an a fortiori case. So even when that person who's sitting there is chairing an administrative body or even a DC, for that matter, at work, that they can advise the employer or the employee in that particular adversarial setting is plainly, one doesn't have to be a lawyer to understand that there's something rotten and wrong with that. So this principle is quite clear.
But you did not bring out the content of the advice. It's just advice in vacuum, the expression advice. The content of the advice, the text of the advice.
Yeah, the content of the, yes, that's one of the defenses. That's wrong, plainly wrong. Because if you go to paragraph 38 of the founding affidavit, and you'll find that in bundle A, sorry. And maybe let me start by explaining the following. The content of the advice, Justice Homer, is specified in the paragraph 38, 39, and 40, which I'm going to read out to you now. Well, one of the things we're told is that we don't say the place, the time, and what the issue you are raising, the content. It's not true. As far as the time is concerned, this is what 38 says. In the build-up to the hearing of the Semenya recusal application, so that's the timing. It was it's not the date, but we situate when it was. Justice Khampepe, as a member of the judiciary and as a decision maker who would ultimately make a final ruling, conducted herself improperly and exhibited actual bias in favor of the non-recusal of Advocate Semenya. And here's the important part. A good example, or shall we say evidence of this, is that Justice Khampepe, without the knowledge of the applicants, privately and secretly gave advice to Advocate Semenya SC on certain key weaknesses in his case, that's the content of the advice, and even advised him on what to look out for and what to convey to his legal representative, Advocate Vasoni SC, in order to succeed in the recusal. That's the content of the advice. This is a case of plain and gross misconduct, irrespective of the merits or demerits of the Semenya recusal application. Then we say at 40, purely in order not to jeopardize ongoing investigation into this serious conduct, which poses a threat to democracy, I deliberately and consciously refrain at this stage from revealing the complete underline complete, evidence available to me. If the accusation is denied, then I will be left with no option but to resort to alternative procedural mechanisms in order to secure or provide the evidence. I trust that this will not be necessary. So this is what happens here. Surely, it should be sufficient. If you allege that advice was given, one, to advise the person on how to succeed, and secondly, to advise him on what to look out for to convey to his legal representative, Advocate Vasoni. Those are specific allegations. How can it be said that the content is not given? Whether that at that point the advice was change this paragraph or that paragraph or look up this case or that case is neither here nor there. The misconduct is in the giving of the advice without the knowledge of the other side. That's where Roberts puts emphasis. There's nowhere in what I read from Roberts that says the judicial aversion, it says should have no communication whatever, right? So whether the communication is X, Y, or Z, doesn't matter. It should have no communication whatever with either party except in the presence of the other. That's the gist of the... It's not even this red herring thing about whether it was secret or whether it was done, whatever. The point is the non-disclosure to the other side of such communication. It's not done. Everybody knows that. Again, one doesn't need to have an LLB to know that a decision maker cannot advise one of the adversaries about anything. It doesn't matter whether it's about a big thing or a small thing or a medium thing. So that's the gist of the attack. And to the extent, to anticipate what my learned friends will say on this, to the extent that, yes, for reasons that I explained here and in the replying affidavit, some of the evidence, because of what is put in there as ongoing investigations, because some of that evidence might not be complete, that's why I put the emphasis on the word complete. Well, so be it. It's not presented. But that's not the test of how you test evidence. There's something in law of evidence called the sufficiency of evidence or the cogency of evidence. So to make a blatant example, if I have evidence that somebody has stolen bread from a store, I can, at that stage, lay a charge against them for that. The fact that it might turn out later that they also stole eggs and they also stole milk and what have you, well, the point is the evidence that's presented at that time sufficient at that time to establish that which I'm accusing the person of? And in our respectful submission, this evidence that is here is sufficient. We agree with our learned friends. They say in the answering affidavit, well, if you don't give us that further evidence, then your application must be dealt with on the basis of the allegations in the founding affidavit. We concede that. We can't expect the tribunal to make a finding with some withheld evidence. But the point is that on the evidence that has been presented in the founding affidavit, there is sufficient for allege, or not allege, to establish, as a matter of fact, that the rule in S versus Roberts was breached. And that's enough.
Yes, you've made your point.
Yes, thank you, Justice Khom. Now, if that, assume now, I mean, there might be engagements on all of this, but for now, I beg the panel to assume that we're correct on those facts. In fact, the reason why you must assume that we're correct is because there is nowhere in these papers where the giving of the advice, which is the gist, is denied. Nowhere. We're given a diversionary story about The only defense actually is that, no, the evidence leaders and the commissioners have frequent interactions. The answer is, so what? Who has disputed that evidence leaders and commissioners have frequent interactions? So it's not the interaction per se, it's the fact that this was an improper communication. Nobody in their right mind will say evidence leaders must not talk to commissioners about the weather or about the matters to do with the terms of reference. But once there is a specific recusal application for a particular purpose, and the commission and the chairperson sends an email that says, please watch out for paragraph 45 or this and that, which is also there in the affidavit, or do this research or whatever, then that's just wrong. I mean, honestly, I shouldn't be standing here explaining that is an affront to the Constitution and an affront to the oath of office to the extent that it is relevant, of any office for that matter. Sorry. Right. Now, the point is this. In the absence, and my learned friends, again, to their credit, they say in paragraph 6, a proper consideration of the affidavits of their heads that have been filed suggests that, save for the allegations made by former President Zuma of improper interactions, and I'll come to that, and Siminya SC, for the most part, the applicable facts are not, in essence, in dispute. That is true, except that the exception that they carve out also doesn't apply. What has been pleaded here, in plain and simple terms, Civil Procedure 101, is what is called confession and avoidance. Now, confession and avoidance means this. You say, yes, the advice was given, or I don't dispute that the advice was given. But, as they say, there's nothing wrong with it because commissioners speak to evidence leaders all the time. But that's what is called a non sequitur, because the fact that evidence leaders, we all know, my learned friend Mr. Siminya and I have been in many commissions together. We know that happens. But that's not the point. That's diversion. It's called a straw man defense. You create your own case and then you fight that case. That's their case. Our case is simple. It's got nothing to do with the frequency of interactions or non-frequency of interactions. It is that in this particular interaction was improper, illegal, and against anything that any decision maker should do. Now,
if I may, you're eating into your time.
Pardon?
I say you have eaten into your time. You have eaten into your 30 minutes. Carry on.
Okay. Thank you.
It's just a friendly reminder.
Yes. No. Thank you. I take it as such. So, the point really being made, and I have to make this point. This is not a complaint about, at least not yet, about misconduct in the JSC sense of the word. Those proceedings, if they happen, and former President Zuma has said that he will institute them, will take their own course. Here, we're only dealing with a narrow issue of whether, assuming that the facts, the confession and avoidance is held to be admitted, because that's really what it is. Okay, let me go to basics. And this will be just the point preceding my last point, Justice Kom.
Mr. Mpofu?
Yes.
Your time has expired.
And that's what Justice
Kom.
Pardon? Wrap up, yes.
Wrap
Okay,
up.
thank you, Justice Khampepe. Now, I'm saying, if, in wrapping up, let me say this. because it's very important that these pleadings must be read for what they are. Confession and avoidance is described as follows. You say, I admit your facts, but even based on those facts, I'm giving you facts that countervail those facts, and therefore a different legal conclusion should be reached. You'll find that in Erasmus, I think it's, yeah, you'll find it in Erasmus. I don't have time to read it out now, but you'll find it at D1-22.8 under confession and avoidance. So you can't have, if you have a confession and avoidance, but you don't put countervailing facts, because the onus shifts in a confession and avoidance. Once you admit, you then have the onus as the admitter to put those countervailing facts. That's known as the Mabaso principle. If you fail to do so, then all we're left is the confession without an avoidance. So the confession is otherwise known as an admission. So those facts are admitted. Secondly, and lastly, and I'm indebted for the indulgence, this principle of failing to deal with such a serious accusation has been dealt with in our courts many, many times. It has been said in old cases, there's a case, just the name just escapes me now, a case, I think it was in the 20s or 30s, where it was found that if somebody makes a serious allegation against you and then you do nothing, you just look down, that is as good as an admission. That has been qualified by the SCA in subsequent cases. But the point I'm making is simply this. Faced with such serious accusations as I've read out, the absence of a denial or any explanation surely means that those facts are common cause. And none other than Justice Khampepe made that point in the case of Public Protector versus South African Reserve Bank, or the so-called CX case. She said at paragraph 190, the Public Protector's failure to deal pertinently and responsibly with the serious accusations made against her impartiality in light of these meetings that she had allegedly had with the President, meant that the High Court was left with only the handwritten notes as evidence of what was discussed at the meeting and no countervailing account from the Public Protector. This led the High Court to conclude that, quote, the question remains unanswered as to why the Public Protector acted in such a secretive manner, and she does not give an explanation for doing so. That is good law, and to the extent that it is good law and it is authority of the Constitutional Court, it must apply here. Because Justice Khampepe was quite correct. When somebody faces a serious accusation against her impartiality, the least you can expect is that they will give an explanation. And if absent that explanation, with the kind of wishy-washy version that we've been given in the answering affidavit, so-called, then the accusation remains unanswered. And if it remains unanswered, the chairperson must recuse herself on that basis alone. Firstly, for giving the advice, for having the communication undisclosed, and for having it in the absence of the other party in these kinds of proceedings. And for the last parting shot is that in the Pinochet case, the famous Pinochet case, the issue of non-disclosure, which really is the nub of this, not the secretive what, the issue of non-disclosure was held in that case as decisive. And I am aware, before somebody reminds me, that that case was decided on the basis of a reasonable apprehension of bias. But everyone knows that actual bias, the alternative to actual bias, if the tribunal doesn't find actual bias, then of course the reasonable apprehension, such as was the case in Pinochet, is sufficient. Because I've run out of time, I will, as I said, defer on the question of the occupational history. I will defer on the question of the occupational literacy to the Mbeki team, but as I say, I stand by whatever is in our papers so that I'm not deprived of dealing with that matter in reply, should it be necessary. I'm indebted for the.
There's just one aspect that
Yes.
my learned colleague would like to deal with you.
Yes.
Thank you.
The first one is just for my own understanding. In the paragraph 15 of Mr. Zuma's affidavit, he refers
Founding. The founding.
I can just you can just listen, but it's paragraph 15. You refer to the commission that had to locate the DSO, the Scorpions, chaired by Judge Khampepe as the Commission of Inquiry. But at 17, the commission chaired by Chief Justice Raymond Zondo, you say the so-called commission